Ladies and gentlemen, welcome to the Lion's Den Show. And here's your host, Cody Robert Judy.
Welcome to the Lion's Den Show. I'm your host and your toast, Cody Robert Judy. Cheers. It's good to be with you today. Today is March 3rd. We've got a stunning show for you, which we're calling Indecision 2012 Republican and U.S. Supreme Court Unannouncements. They just can't get their potatoes right. Now, I'm a natural-born citizen of Idaho, famous for potatoes. So when it comes to potatoes, I get it right. Now, just a sniff of a background check on the U.S. Supreme Court. We all know that they are the Supreme Court of the United States, and most of the time, that is said with a great deal of respect. That respect doesn't come from the distinguished people serving on the U.S. Supreme Court. That respect comes from our U.S. Constitution, from which the U.S. Supreme Court was actually given life and thereby received a first breath. Without the U.S. Constitution, does the Supreme Court even exist? No, it does not. Does the U.S. Supreme Court die and its breath is taken away without the U.S. Constitution? Yes. That's just a little perspective on the honor that should be given the U.S. Constitution. Now, in a stunning move, on March 4th, 2011, the U.S. Supreme Court will hold a conference on a legal challenge to Barack Obama's eligibility to occupy the Oval Office, where the court is not answering questions about whether two justices given their jobs by Obama will participate. However, a Democrat congressman from New York has laid the argument down why those two appointments by Obama should not participate and recuse themselves. Yeah, Democrat. If any of you saw the rounds of Megyn Kelly and New York Congressman Weiner regarding U.S. Supreme Court Justice Clarence Thomas speaking out amid healthcare recusal, you'll find the Democrat congressman has just spoken very clearly and articulated on the reasons that Obama's appointments of Justices Sonia Sotomayor and Elena Kagan, who were given their jobs by Obama, should have recused themselves, which they didn't during the first round. I want to commend the Democrat New York Congressman Weiner for boldly coming out on behalf of this argument. That takes guts when Obama is a Democrat too, and it shows the country that not all Democrats are with the fraudulent actions of Obama, and the Constitution can indeed actually be the common ground between all political agendas. Here's where you can find Democrat Congressman Weiner's argument right here on the YouTube station. The confirmation of that argument is actually confirmed by the U.S. Supreme Court themselves in this second conference scheduled for March 4th. That's tomorrow. Brought to them by attorney John Hemingway on behalf of retired Colonel Gregory Hollister, and it will be the subject of the conference on March 4th. It was in January that court first denied the case without comment, a request for a hearing on the arguments. But the attorney at the time had submitted a motion for Justices Sonia Sotomayor and Elena Kagan, who were given their jobs by Obama, to recuse themselves from the conference. Obama has been shown by one court already to ultimately have been ineligible for office. Now, his fraudulent actions may have produced a domino effect that will include his appointments and every piece of paper he has put his signature on over the last 2 years. He has ineligibly occupied the White House. At the time, the Supreme Court acknowledged the motion for recusal, but the court changed it on official docketing pages to a request instead of a motion, and it failed to respond to it, which is a violation of its own rules. This is one example of the highest court in the land's ability to cover its tracks, no doubt with some lost integrity. It is a powerful example, however, that when true identity of the Constitution is at stake, that it takes clear, illegal actions to pull a stake from the Constitution's foundation. Hemingway then submitted a request for a rehearing, pointing out that the situation appeared to be a violation of the rules of the U.S. Supreme Court. This is a clear reminder that the U.S. Supreme Court justices are indeed capable of breaking the law from which they were charged to uphold. The condemnation of the United States and indeed the eyes of the world have been shown this judicial embarrassing moment for the honor of our U.S. Supreme Court and Constitution. The names of the justices which have drank from the same trough of fraud that Obama has are as follows. First and foremost, as a matter of course, Justice Sotomayor and Kagan, truly grounds for their seats to be tried and revoked. Justice Kennedy, Scalia, Roberts, and Thomas, as well as Justice Breyer, Ginsburg, and Alito, share in this embarrassing debacle and have brought shame to the U.S. Supreme Court and the honor to the contemplating justice. John Hemingway presented the case with integrity and honor to the U.S. justices. He wrote that if the court members continue to avoid the dispute, they effectively will destroy the constitutional rule of law basis of our legal system. Effectively, concurring with my sentiments, the U.S. Supreme Court itself will be destroyed. They will be out of a job and may become trough feeders at Leavenworth, where Lieutenant Colonel Terry Lakin is now. Can anyone think of a reason why they shouldn't be? The real question here is one of getting members of the judiciary to take seriously the oath that they swore to protect and preserve the Constitution. Hemingway wrote in his petition for a rehearing, "To continue to avoid the issue will destroy the constitutional rule of law, basis of our legal system when it is under vigorous assault, as surely as if the conscientious decision were made to cease preserving and protecting our founding charter." We've not exaggerated in presenting the question of this constitutional rule of law being at stake in this matter. Hemingway wrote in a petition for rehearing before the High Court, "A man has successfully run for the office of president and has done so, it appears, with an awareness that he is not eligible under the constitutional requirement for a person to be president, despite a vigorous campaign that he has conducted to make unthinkable the very idea of raising the issue of his eligibility under the Constitution to be president. The issue has not gone away," Hemingway said. "Instead, it has steadily grown in the awareness of the public. Should we be surprised that Obama shows no respect for the constitutional rule of law? What else would we expect?" he wrote. That the justices are avoiding the Obama issue already has been confirmed by one member of the court. It was last year when Justice Clarence Thomas, who appeared before a U.S. subcommittee when the issue arose. Subcommittee Chairman Representative Jose Serrano, another Democrat from New York, raised the question amid a discussion on racial diversity in the judiciary. "I'm still waiting for the court decision on whether or not a Puerto Rican can run for president of the United States," said Serrano, who was born in the island territory. "That's another issue." Yet after Serrano questioned him on whether or not the land's highest court would be well served by a justice who had never been a judge, Justice Thomas not only answered in the affirmative, but also hinted that Serrano would be better off seeking a seat in the Supreme Court than a chair in the Oval Office. "I'm glad to hear that. You don't think you have to be a judge on the court," said Serrano, "because I'm not a judge. I've never been a judge. And you don't have to be born in the United States," said Thomas, referring to the Constitution, which requires the president to be a natural-born citizen, but has no such clause for a Supreme Court justice. "So you never have to answer that question." "Oh, really?" asked Serrano. "So you haven't answered the one about whether I can serve as president, but you answered this one." "We're evading that one," answered Thomas, referring to a question of presidential eligibility and prompting laughter in the chamber. "We're giving you another option. You can see the YouTube video and the conversation here." Now, the motion to the court made by Hemingway was never responded to by Obama. Therefore, as a matter of due process of the court, petitioners suggest that the court should have on that day considered the possibility that the motion has been conceded by the respondents with an examination of the consequences of that failure, Hemingway explained. "If petitioner has entitled to have their motion for recusal as conceded because of lack of timely opposition, as petitioners contend in this case, then the court was obliged to make sure that the Justice Sotomayor and Kagan did not participate in the decision. Yet there was no statement that they did not participate, the brief states. The brief further argues that because of the lack of response or acknowledgement by the court should have to consider the law of nations on matters of citizenship, such as the phrase in question here is placed in Article 2, Section 1, Clause 5, namely the requirement that a president be a natural-born citizen. The argument continued. Thus, it would seem, with all due respect, that if the court is required to and does not treat the petitioner's motion for recusal as conceded, the court would be required to consider the intent of the framers of the Constitution in choosing the Article 2 phrase, natural-born citizen. That is, of course, assuming that the majority of its members still believe that the intent of the framers is essential to the constitutional rule of law in this country, the filing said. In the original petition of the High Court, the pleadings note that if Obama is not constitutionally eligible, it will create a crisis. If proven true, those allegations mean that every command by the respondent Obama, and indeed every appointment by respondent Obama, including the appointment of members Elena Kagan and Sonia Sotomayor, of this and every other court may be only de facto but not de jure by right of law, stated the pleading. Further, his signature on every law passed while he occupied the Oval Office is not valid if he is not constitutionally eligible to occupy the office de jure, it continued. Thus, it is not hyperbole to state that the entire rule of law based on the Constitution is at issue. Moreover, it would indicate that the respondent Obama ran for the office of president knowing that his eligibility was at the very least in question, it continued. It appears from the court documentation that Kagan and Sotomayor actually participated in the conference, the meeting at which the Supreme Court justices determine which cases they will take. On other cases, there are notations that Kagan and Sotomayor did not participate, and the Hollister case is without any such reference. Although proceedings are not public, it is believed that the case must earn 4 votes among the 9 justices before it is heard. On the conservative side, generally Chief Justice Roberts, Justice Samuel Alito, Scalia, and Thomas. Justice Anthony Kennedy often is a swing vote. The liberal side frequently included Justice Stephen Breyer, Ruth Bader Ginsburg. The construction of this case is a witness to the conservative American citizen that the Republican Party, as well as the contemplations of justice at the party alliance, which is not what it used to be. Let me divert your attention here, Republican citizens. Where are the Tea Party champions? Where are the conservative candidates for president in 2012? Where are those illustrious CPAC speakers and straw poll winners in this moment of American history? Where is Ron Paul? Where is Mitt Romney? Where is Sarah Palin? Where is Chris Christie? Where's John Huntsman? Where's Mitt Romney? Where's Mike Huckabee? Where is Michelle Bachmann? Where is Newt Gingrich? Where is John Bolton and Gary Johnson? Just the other day they were leaders at CPAC, which stands for Conservative Political Action Committee, and not one of those speakers or people had a thing to say about this, either on stage or via satellite or via Twitter or blog. Don't get me wrong here, because my champions, and I believe in them, are the conservative American citizens. These are the people who I trust. It is not those individuals I mentioned who I trust, but they have shown you their colors, and they do not have the courage to lead this nation. They have already let you down. I ask them to do all of the conservative citizens a favor and do not declare their candidacy for President of the United States. You've already, as leaders, let us down. This will not go away. It's going to be remembered for more than 1,000 years. It was their choice to appease Obama eligibility. Is that the kind of courage we need as a nation now? Is that the kind of courage that left the black man in chains and his slaves? Yes, it is. Does every black man owe a debt of gratitude for the courage of Lincoln to fight the Civil War for the freedom and liberty of every American? It cost us 625,000 lives, that Civil War did. But how many lives were made better by the decision and courage of President Lincoln throughout history? Do you think that million-man march would have been nearly as impressive if the millions were in chains? To what honor do you owe the freedom and liberty you now enjoy under the U.S. Constitution if it is not to the men who had the courage to fight for your freedom? Now, do you seek to subvert the Constitution because of a half-black and a half-white man who's fraudulently identified himself as qualified for the office when he was not? Are you willing to give up the courage that has been in your favor for this cowardice of fraud named Obama? What gratitude do you have towards Almighty God in throwing in with the cowards who eat slop in the trough of hell with all of the CPAC speakers? The Conservative Political Action Committee report proves an utter conservative and constitutional failure in their straw poll. What could one expect when they all went on a drinking binge with Panama native son and citizen John McCain? Can you believe I was not invited to speak at CPAC? I'm a conservative and I'm running for president. You'll also find my name, Cody Robert Judy, under Patriot of the Constitution. You'll also find my name opposing John McCain and Obama in the Federal District Court in Las Vegas, Nevada. The only candidate in the field of 2008 presidential candidates who opposed both. You'll find my name pleading for Lieutenant Colonel Terry Lakin as a friend of the court. And you'll find my witness testifying at the CIA Columbia-Obama trial in New York. The question you must answer is, where are your Republican champion conservatives who can say the same? They are nowhere. There was none who had the courage for our Constitution to lay their life on the line. What sort of leader do you want? Would you be voting for Obama if you knew he was selling the future generations as slaves? What is a violation of our Constitution? You have no right to sell our future generations. Period. You do not hold that right in your position, and your position does not advocate that right to you. You do have a bankruptcy option, which is your right if you have mishandled your generation's money, but you have no right on the future generations of this country. It was a fool's bet that you thought you could buy American boys and girls? The United States Supreme Court was established under the U.S. Constitution. But if there is no U.S. Constitution, there is no U.S. Supreme Court. And if there is no U.S. Constitution, there's certainly no Congress either. Get it? Charles E. Rice, Professor Emeritus at Notre Dame Law School, has noted in his argument concerning Obama's eligibility the classic formulation of the congressional role in Woodrow Wilson's 1984 book Congressional Government, citing, "It is the proper duty of a representative body to look diligently into every affair of government, to talk much about what it sees. It is meant to be the eyes and the voice, and to embody the wisdom and will of its constituents. Unless Congress have and use every means of acquainted itself with the acts and the disposition of the administrative agents of the government, the country must be helpless to learn how it is being served. And unless Congress both scrutinize these things and sift them by every form of discussion, the country must remain in embarrassing, crippling ignorance of the very affairs which it is most important that it should understand and direct. The informing function of Congress should be preferred even to its legislative function. The only really self-governing people is that people which discusses and integrates its administration." That's on page 198. Congress has an informing function. The investigatory power has remained as an essential role of Congress. The Constitution nowhere expresses or grants to either House of Congress a general power to investigate in aid of legislation or in aid of overseeing the executive branch. However, the Supreme Court has long recognized that such power is implied as an essential concomitant to Congress' legislative authority. John E. Nowak and Ronald D. Rotunda, Constitutional Law 204-280, also seen Grain v. Darby 273 U.S. 135, 1927. The power to investigate also includes probes into departments of the federal government to expose corruption, inefficiency, or waste, does it not? The authority to investigate necessarily requires the power to compel testimony. Erwin Chemerinsky, Constitutional Law of 2006, 310, International Citation permitted. The power to investigate can be exercised by a House committee, provided that the investigation is within that committee's authorization as determined by the House. An investigation into Obama's eligibility by a committee or a subcommittee of the House could have several legitimate objectives, including, among others, 1. To ascertain the facts compelled by subpoena, the production of all the available records relevant to Obama's eligibility, including the complete Hawaiian record of his birth, his passport records to ascertain whether he traveled to Pakistan in 1981 as an American or on another passport, the records from the Occidental College, Columbia University, which we don't think he went to, and Harvard Law School, which is also probably a fraud, to determine whether Obama described himself as a foreign student, and such other records as may be relevant. The disclosure of such information to the public would be an appropriate exercise of Congress and their informing function. The consideration of legislation to require a candidate for a federally elective office to produce, at an appropriate time, evidence of their eligibility for that office. There is now no federal law or regulation that requires such disclosure, although there is criminal law against fraud and representing yourself as someone that you're not. The consideration of legislation to define the constitutional term, a natural-born citizen. The American people do not know whether the current president achieved election by misrepresenting innocently or by fraud and eligibility for that office. It would be a public service for the House of Representatives to employ its authority to determine those facts and to recommend any indicated changes in the law or the Constitution as a matter of their sworn duty to uphold their oaths. In light of another Democrat coming forward and stating Obama's long-form birth certificate is nowhere to be found, as stated by the governor of Hawaii, Neil Abercrombie, but we don't need that information. When we all know Obama's natural-born inheritance is the subject of written from his father. I'm sorry. We discriminate when it comes to the highest office of the land in America for a good reason.